Hi. If you live in New York State and you're having difficulty evicting tenants from a property that you own, this video is for you. I'd been renting out my condo in the town of Somers, New York in Westchester County for the past 10 years. About 8 months ago, I decided that I would sell my property. And at that time, I gave my tenants notice that I wouldn't renew their lease when it expired on April 8th, 2022. But my tenants were still in the condo on April 9th, so I began eviction proceedings. I didn't want to pay a lawyer a lot of money to resolve the issue, so I filed the paperwork myself and represented myself in court. Once you know what needs to be done, the procedure isn't difficult. I was able to get them out in 19 days. It's unlikely that the process could be completed in less time than that, as the tenants have to be given at least 7 days between the time that they're served with a notice to appear in court and the date of that court appearance. In the town of Somers, landlord-tenant disputes are heard every Monday evening at 5:30 p.m. at the Justice Court. I served my tenants on a Wednesday, so the court appearance happened 12 days later. Now, here are some disclaimers. First, I'm not a lawyer, so I'm not providing legal advice. I'm just describing my experience. And my experience is specific to the town of Somers in Westchester County, but I believe that the rules are similar throughout most of the state, except for New York City, where the regulations may differ significantly. I'll provide links with more information on the procedures. My tenants signed a standard New York State lease agreement with a term of a fixed number of years and a specified termination date. I'll provide a link to the form for that document. Now, your eviction will be much more difficult if you rent month by month or rent without a formal lease. Now, here's the most important thing you need to know. If your tenants signed a fixed-term lease like mine did, and they want to pay rent to stay longer, for example, on a per diem or monthly basis, you must say no. If you accept any rent for an overstay, then the lease will revert to a monthly lease, and you'll have a great deal of difficulty evicting your tenants. So instead, just begin the eviction proceeding. A judgment in your favor will likely grant you rent for the overstay with interest. Now, when you evict tenants who have a fixed-term lease, this is known as a holdover summary proceeding. This is totally different from evicting a tenant for non-payment or for breaking rules, or in the case where the tenant is renting on a month-by-month basis. So there's a specific set of forms that you must submit to the court in the case of a holdover summary proceeding. In the description, you'll find a link to a PDF with all the forms as well as instructions. You must submit all of these forms with one exception. You submit either an affidavit of personal service or an affidavit of substituted or conspicuous place service. The first form is used if you had someone hand documents directly to your tenants. The second form is used in all other cases. I'll describe filling out these forms in more detail later. Fortunately, each document is accompanied by a very clear and complete set of instructions. You must follow these instructions exactly. The court clerk will likely not tell you that you've done something wrong, as he or she is not allowed to provide legal advice. When you first look at the documents, the procedure could seem a bit daunting. But if you take it step by step, it's not bad. You could save yourself thousands of dollars. And if you do it right and win your case, there's a lot of satisfaction in doing it yourself. The instruction portion of the packet contains a lot of useful information, so I suggest reading it carefully. The first document you'll need to fill out is the Notice to Terminate. Here are the instructions. Item 2 wasn't completely applicable to my property, but I filled it out as best I could, and it was fine. In Item 4, I specify that the condo is used as a residence. So above Item 5, it says tenants, under tenants, or assigns, and every person in possession of the premises. This is a little different from the instructions for items 7 and 8. So I followed the instructions on the document itself, and I listed everyone residing at the premises. So the next item is called Notice of Petition, Holdover Proceeding, and you'll see the instructions. So item 3 you can't fill out until you bring this document to the court clerk, and they'll assign you a docket number. The same is true of item 8. The court clerk will assign a day and time, so you can fill in these items when you bring the document to the court clerk. In my case, when I went to the court clerk and handed in these documents, I paid a $20 fee in order to be assigned a docket number. For item 11, you indicate the size of the judgment you're asking for. During the court appearance, the judge told me that he normally doesn't award damages beyond back rent with interest and filing fees. But there's no harm in trying if you think you have a legitimate claim. I had been claiming airfare back to New York, and the judge told me that he wouldn't grant that. When you bring this document to the court clerk, the clerk will stamp it or sign it, and this is a paper that will be served to your tenants to inform them about the court case. Now, you're not permitted to serve this document yourself to the tenants. You have to have someone do it. It can be a friend or an acquaintance, or you can pay a process server to serve it. But I had a friend do it, and that worked out perfectly fine. The next document is called the Holdover Petition to Recover Possession of Real Property. And this is a document that you have notarized and you submit to the court. It's not served to your tenants. Again, item 3 is filled in when you get a docket number from the court clerk. In item 12, I indicated that I have no undertenants. In item 15, I checked the box that said that the agreed-upon time period of the lease has ended. That is, it wasn't a verbal agreement. For item 16, I indicated that ETPA, or rent control, was not applicable to my property. The form continues on a second page. Item 16 is continued. So I checked the box that says that the premises are located in a community which has not adopted ETPA, or rent control. I also indicated that the building in which the premises is located has less than 6 units. Mine has a single unit. For item 17, I indicated that I have no information regarding the place of employment of my tenants. In fact, they're retired. In item 18, I checked the second box, indicating that the tenants were given notice. I indicated that the property that I want to have them vacate is the residence of the tenants. For item 25, I indicated that I'm the petitioner. That is, I'm submitting the application myself. And then the bottom of the form has to be filled in and stamped by the notary. The next document in the packet is the Affidavit of Personal Service. The second document you filled out in this packet was called the Notice of Petition Holdover Proceeding. That document notifies your tenants of the court proceeding. One way to notify your tenants of the court proceeding is to have someone hand your tenants that document. The person who does this can be a friend or an acquaintance, or you can hire a process server. You can't do this yourself, and the person who does it can't be a party to the suit, and must be over 18. I had a friend do it. Again, item 3 is filled in after you get a docket number from the court clerk. Whoever serves the document has to fill out item 13, describing the person that the document was handed to. This could be any of the tenants named in the suit. The bottom of the document is then notarized. Note that the person whose name appears in item 14 is not your name, but the name of the person who handed the document to your tenants. Items 14 and 15 shouldn't be filled in until you're in the presence of the notary. The Somers Town Hall provides notary services for free, as do a number of local banks. Items 8 and 14 are not filled in with your name, but with the name of the person who hands the notification to your tenants. Item 9 is filled in with the exact name of the document that was served to your tenants. This is called the Notice of Petition Holdover Proceeding. The next document is called the Affidavit of Substituted or Conspicuous Place Service. It's an alternative to the previous document, the Affidavit of Personal Service. This document is used when your tenant doesn't accept the Notice of Petition Holdover Proceeding. In that case, the person trying to serve the document can leave the document at the door or can hand it to someone at the premises in order to give it to the tenants. In these cases, however, a copy of the document must also be sent by certified mail to the tenants. If the document is handed to someone, not the tenants, then a description of that person is included in this Affidavit of Substituted or Conspicuous Place Service. Whether the document was handed to someone or left under the door, the affidavit must also describe that the notification was sent by certified mail to the tenants. You may wonder why the document isn't just sent by certified mail in the first place. The advantage of leaving the document or handing it to someone is that the date and time of the notification occurs when the document is left or handed to someone, and not when the certified mail is received by the tenants. This may save you a few extra days in the process. Item 21 is filled in with the name of the person attempting to hand the notification to your tenants. The person serving the document must, of course, be present when the affidavit is notarized. The next document, the Holdover Judgment, is easy. You're only filling out items 1 through 9, and this is all material that you've supplied before. This form will eventually be used by the court in order to record the judgment in your case. The document Warrant of Eviction Holdover is also easy. You only fill out items 1 through 11, and this is again information that you've already supplied. After you win your case, this form will go to your county sheriff. It provides the sheriff with the instructions needed in order to actually evict your tenant. Hi. Well, now that you've won your eviction case, it's time to kick back and relax. And what better way to relax than with a good novel? So let me recommend my book, The Vientiane Affair. This is a political thriller that takes place in Laos in the early 1960s, just at the beginning of the CIA's secret war in that country. When Fred Jenkins, an aid worker, is found floating face down in the Mekong, Jack Gold wonders what happened. After all, Jenkins didn't have an enemy in the world. Just about the same time, a new aid worker arrives at the embassy in Vientiane. Gold, a CIA agent, generally didn't pay much attention to the aid workers, but this flaming redhead caught his attention. So if you enjoyed this video, you could give me a thumbs up or subscribe to this channel. But I'd really prefer if you bought one of my books. So have a look in the description section where you'll find information about ordering my books in ebook, print, or audiobook format. Personally, I recommend the audiobook. Anyway, back to your court case. So let's summarize now the forms you need to submit to the court clerk. The Notice to Terminate is the document indicating that you expect your tenants to vacate your premises by a particular date. The document isn't notarized, and you're not responsible for delivering this notification to your tenants. The Notice of Petition Holdover Proceeding is a document that will be served to your tenants in order to notify them of the court case against them. You'll bring this document with your other documents to the court clerk. You'll pay a fee, and the court clerk will assign you a docket number, and you'll write the date and time of your court case on item 8 of this document. The court clerk will sign this document. He or she will keep a copy and return a copy to you. That copy is what you will have served to your tenants. The next document is the holdover petition to recover possession of real property. This is your petition to the court to request that your tenants be evicted from the property. When you visit the court clerk with your packet of documents, you'll be able to get the docket number to fill in item 3 of this form. But then you'll have to take this form to a notary and bring it back to the court clerk, notarized. The same docket number will go on the Affidavit of Personal Service or your Affidavit of Substituted Service or Conspicuous Place Service, depending on which one you submit. You won't turn in this document to the court clerk at this time. After you serve the Notice of Petition holdover proceeding, then you'll notarize either the Affidavit of Personal Service or the Affidavit of Substituted Service or Conspicuous Place Service, having the person who served the Notice of Petition provide their signature on the document. You'll have to return to the court clerk with one of these documents notarized after the Notice of Petition holdover proceeding has been served on your tenants. You give the Holdover Judgment and the Warrant of Eviction holdover to the court clerk. These documents don't need to be notarized. To summarize, the first time you visit the court clerk with your documents, you'll give the clerk the documents Notice to Terminate, Notice of Petition, Holdover Proceeding, Holdover Petition to Recover Possession of Real Property, Holdover Judgment, and Warrant of Eviction, Holdover. When you're at the court clerk's office, you'll pay a fee and you'll be given a docket number and a date and time of the court proceeding. You'll fill these in on the documents. You'll need to notarize the form Holdover Petition to Recover Possession of Real Property. Then bring the notarized form back to the court clerk. The court clerk will give you back a signed copy of the Notice of Petition holdover proceeding. This is the document that you'll have served on your tenants. After the Notice of Petition is served, then you'll have either the Affidavit of Personal Service or the Affidavit of Substituted Service or Conspicuous Place Service, and you'll return the notarized copy to the court clerk. When you're all done, the court clerk will have 6 documents that you've provided. Now you just need to show up in court on the assigned date and time. You'll want to have with you the tenant's lease, the deed and title, and any other evidence in your case. If you've filed all these documents correctly, you should have a very strong case. So just sit back and enjoy the proceedings. You've worked hard to get here. Dress neatly, but it's not necessary to wear a suit and tie. Wait to be called up. Your tenants and or their lawyer will also be called up. It's likely that the first thing that the judge will do is to ask you whether you've attempted to reach a settlement. I hadn't, and my tenants and I were sent into a side conference room where we were given the opportunity to reach a settlement. My tenants agreed during this conference to leave within 2 days and to pay back rent with interest and court fees. I had attended the court the week before just to see what the proceedings were like, and one thing I observed is that nearly all cases are settled. In my case, the judge told me that if we didn't settle, we would have a trial at the end of the night, but that I wouldn't receive any more than back rent and interest and court fees, and so he encouraged me to settle, provided that the tenants were willing to leave quickly. So there was little to gain by going to trial. This sort of settlement is very common. When we returned to the courtroom, I explained the settlement to the judge, and I asked the judge how I could be certain that I would get my payment and that my tenants would vacate in 2 days as we'd agreed. The judge swore us all in, and he dictated the terms of the settlement to the court reporter. He warned all parties that if they agreed to the settlement, they must fulfill all terms of the settlement. I had agreed to accept back rent in monthly payments. The judge warned my tenants that if they missed a payment or bounced a check, he would order them to immediately pay the full amount. He also told them that they must vacate the premises as they agreed in 2 days. He individually polled all of us, asking us if we agreed to the settlement. The judge told me to tell him immediately through the court clerk if there was any violation of the settlement. I was happy with the outcome, and my tenants were out in 2 days. If you can't reach a settlement with your tenants, the case will go to trial. But if you've filled out all the paperwork correctly, it's likely that you'll win. The case of a holdover proceeding for a fixed-term lease in New York State is probably the most straightforward case of an eviction proceeding. If your circumstances are different, for example, if your tenants have a month-to-month lease or no lease, or if you're evicting them for non-payment or evicting them for breaking rules, then you need a different set of forms. I provided a link to the website in the description. But just a reminder that this type of proceeding is more complicated and you might want to consider getting a lawyer. If you've had other experiences with this type of eviction, or if you have useful information about other types of evictions, please post them in the comments section. So I hope this video was helpful. If it was, feel free to leave comments, or if you have questions, maybe I'll be able to answer them. So good luck evicting your tenants.